Racial bias, a controversial issue in the criminal justice system. A New York Times op-ed, it focuses on it. Here's a portion, quote, far too often in criminal or death penalty cases that involve a black defendant, prosecutors try to exclude black jurors because they believe it will increase the chances of a conviction. In Houston County, Alabama, prosecutors struck 80% of qualified black jurors from death penalty cases between 2005 to 2009. Well, Judge John O. Newman, he wrote that piece, and he's a senior judge in the United States Court of Appeals. You know, before we get to the specific case in question and some of the lessons you think it teaches, give a little 101 for our audience as it relates to peremptory challenges, both what typically you'll see in a state case versus at a federal level, and how there's a distinction between a normal federal felony case and a death penalty one.
Well, the peremptory challenges don't really vary from state to federal, except as far as quantity. The states are free to allot as many peremptory challenges as they want, and sometimes they allot more than the federal, although in death penalty cases it's frequent to allot each side 20 peremptory challenges. That simply means that a prospective member of the jury can be challenged by a lawyer for any reason at all, whereas challenges for cause are quite different. If the lawyer says, look, this fellow on the potential juror knows the defendant, or he knows the lawyer, or he says he can't be fair, those are challenges for cause. And there's no limit on those, and I'm not suggesting there should be. Peremptory challenges are where the lawyer says, I just don't want this person on the jury, and he articulates some reason. He says, well, I don't like the way he looks at me, or he seems too old, or he seems too young. Reasons that have no relationship to the specifics of the case at hand. Those are peremptory challenges, and they have a numerical limit. And as I say, it varies from state to state, but in death penalty cases, it's often 20.
Well, in this Supreme Court case that they ruled on a few weeks back, it was notable to some of the attorneys I spoke to, not because it was this extraordinary case, but because the counsel were so stupid as to basically leaving a trail of breadcrumbs by identifying the jurors strictly because of their race. How often does this happen where they will strike people from a potential jury pool because of the color of their skin? Does this happen more than the public imagines?
Challenging jurors because of their race happens very commonly. Statistics show a very large number of all-white juries, particularly in the southern states. Not at all unusual. What was unusual in the recent Supreme Court case is that the prosecutors provided virtually indisputable evidence that their motive was racial. They took the list of potential jurors, they put a B for black next to every African American before they even began exercising their peremptory challenges. And so it was pretty clear to the Supreme Court that this was a racial use of peremptory challenges. You will rarely see a case with evidence that strong. And so although the court found racial bias in the use of peremptories in that case will really not be of any value to African American defendants making challenges in the future, because it's very unlikely any prosecutor will provide a record so blatant as occurred in that case.
We'll get to your proposal in a second, but from the basic premise of peremptory challenges, if it was up to you, would you just outright get rid of them altogether, or do you believe that, as you say at the end, limiting it to, let's say, 2 or 3 is sufficient? Is there a place for them?
Well, yes, I suppose there's a place for at least one. I don't mind if a lawyer looks over the potential jurors and says, you know, that one fellow sitting there in the 4th row of the jury assembly room, or wherever they pick the jury, I just don't want him on the jury. I can't quite tell you why, but in my gut he just looks to me like he's either not paying attention or there's something rather weird about him. So I wouldn't mind allowing one. When you start having 6, 8, 10, or 20, you open the way for racial challenges.
If, in fact, they adopted your proposal and they limited it to 1 or 2, Would there be material difference, do you believe, in cases where the defendant is looking at the death penalty and he's a person of color?
That's very hard to know. I'm not sure there would be much of a difference. My main concern is partly that the outcomes might be different in a few cases, but what would be true in all cases is the public's perception of justice. When an all-white jury, in a case where there's a white prosecutor and a white judge, and the defendant is an African American, and that all-white jury brings in the death penalty, the African American community, and indeed the white community, understandably has doubts about the fairness of the system. So even if having a jury composed in part of African Americans along with whites or Hispanics, even if that jury would have come to the same conclusion on the death penalty, and they might have, the appearance that justice was done will be acceptable. Whereas when it's an all-white jury, minority communities are understandably doubtful that justice was done. And certainly the appearance is that justice was not done.
Justice Newman, thank you so much. I do appreciate a few minutes. And coming up next, we'll take a look at some local headlines.